Hello, everyone, and welcome to Uncivil Law. I'm joined today by my friend Tactical Bra, and today we are going to be talking about the case from the Eastern District of Arkansas, Turtle Island Foods, doing business as the Tofurky Company, versus Nickel Salmon. In this case, the state of Arkansas passed a law that prevented any plant based meat product from describing themselves as meat on their packaging. The Toferky Company has sued, arguing that this law is silly. The Eastern District of Arkansas is here to analyze the law, so let's see what they have to say and get started with this. All right, let's do
I know.
Toferky.
Woohoo!
Toferky brings this action seeking declaratory and injunctive relief to challenge the constitutionality of the Arkansas Act. Specifically, Toferky challenges six provisions from the Act. Tofurky asserts that these provisions represent a restriction on commercial speech that prevents companies from sharing truthful and non-misleading information about their products, does nothing to protect the public from potentially misleading information, and creates consumer confusion where none existed before to impede competition. So this case serves both as a good review of the issue at hand, whether or not Tofurky can label their products as meat sounding words even though they contain no meat, and also the broader principles as it relates to commercial speech versus other kinds of speech because there are different constitutional standards. Tofurky is a social purpose corporation incorporated in the state of Washington and headquarters in Oregon. I have absolutely no idea what the legal significance of being a social purpose corporation is. Tofurky develops, produces, markets, and sells plant-based food products, including plant-based meats. Plant-based meats are typically made from soy, tempeh, wheat, jackfruit, textured vegetable protein, and other vegan ingredients. The texture, flavor, and appearance of plant-based meats resembles meat products made from slaughtered animals. Unlike animal-based meats, however, plant-based meats are made from vegan ingredients. The products are marketed and sold nationwide, including throughout Arkansas. What terms are they using that Arkansas argues are potentially misleading? Tofurky uses traditional meat-based terms like chorizo, ham roast, and hot dogs, alongside qualifiers like all vegan, plant-based, vegetarian, and veggie, to show its products are plant-based meats that can be served and consumed just like other meats. The dispute regarding the act notwithstanding, Tofurky's products, including its plant-based meat products, comply with federal food labeling regulations as well as numerous state and federal laws that prohibit false and deceptive labeling and marketing for food products and consumer products more generally. The stated legislative purpose of the Act is to protect consumers from being misled or confused by false or misleading labeling of agricultural products that are edible by humans. To that end, the Act outlaws misbranding or misrepresentation an agricultural product edible by humans by, for example, representing the product as pork or pork product when the product is not derived from domesticated swine. Only the best domesticated swine will do.
Not wild feral hogs.
No. As applied, the Act prohibits Tofurky from using words like meat, beef, chorizo, sausage, and roast to describe its plant-based meat products. Tofurky asserts that the Act might even prohibit Tofurky from accurately describing its products in marketing and on packaging. The statute provides no exception for plant-based meat producers that are clearly identifying their products as being vegetarian, vegan, or made from plants. Tofurky estimates the cost of changing its marketing and package practices nationwide would verge on $1 million, and even still it might be impossible to ensure no nationwide marketing enters Arkansas. Further, Tofurky alleges that it's logistically and financially impractical to create separate products to be sold within Arkansas. Instead, Tofurky claims it would be forced to stop selling products in the entire region. Finally, Tofurky believes compliance with the Act may be bad will for Tofurky, as customers may be confused by the language required by the statute. If Tofurky is prohibited from using terms like burger, chicken, and sausage, customers may not understand what they're buying. When determining whether to grant a motion for a preliminary injunction, this court considers the threat of irreparable harm, the state of balance between this harm and the injury, the probability the movement will succeed, and the public interest. This is the standard four-part test used nationwide for acts of injunction. This balancing test is used for all sorts of balancing tests nationwide. In its motion for preliminary injunction, Tofurky challenges 6 provisions from the Act, as violating the free speech clause and due process clause. The court considers Tofurky's likelihood of success on the merits of the First Amendment claim, determines Tofurky has demonstrated it's likely to prevail on the merits, and therefore declines to reach the 14th Amendment claim. So the court here is saying that the law as it applies to this issue is a violation of the First Amendment. Let's read on. Now the court is going to lay out the legal standard as it applies to commercial speech, which is a different standard of review from other kinds of speech. So let's read on. Commercial speech is generally defined in one of two ways: expression related solely to economic interests of the speaker and his audience, or speech proposing a commercial transaction. That would be an advertisement. The First Amendment, as applied to the states, protects commercial speech from unwarranted governmental regulation. In analyzing restrictions on commercial speech, the Supreme Court articulated an intermediate scrutiny framework for commercial speech in Central Hudson. So some kinds of speech are strict scrutiny, some kinds of speech are rational basis, and intermediate scrutiny applies to commercial speech. So they're at an intermediate level, so much regulation that would apply in non-commercial speech does apply in commercial contexts. Let's read on. Under the Central Hudson test, courts consider the test of constitutional laws burdening commercial speech by considering whether the commercial speech at issue concerns unlawful activity or is misleading, whether the governmental interest is substantial, whether the challenged regulation directly advances the government's interest, and whether the regulation is no more extensive than necessary. Provided that the speech is not false or inherently misleading, each of these latter three inquiries must be answered in the affirmative for the regulation to be found constitutional. When the particular content or method of advertising suggests it is inherently misleading, the state may impose appropriate restrictions without violating the First Amendment. Inherently misleading speech is speech that inevitably will be misleading to consumers. The inherently misleading character of speech may be inferred from the particular content or method of the advertising, as well as experience that is proved to be such fact is subject to abuse. Misleading advertising may be prohibited entirely. So non-commercial speech is not typically subject to these statements requiring truth. But however, commercial speech is. So among other things, commercial speech can be regulated to ensure that's true and not misleading. And if it is misleading, it can be prohibited in the commercial context. So advertisements have to be true and they cannot provide inherently misleading stuff. Now, that does not extend to puffery, statements that no reasonable person would believe. So something like world's best coffee is not understood to be a literal statement of fact. It's understood as puffery. But otherwise, commercial ads have to be, generally speaking, true. And if not, they can be regulated out of existence. However, if the communication is neither misleading nor related to unlawful activity, the government's power is more circumscribed, and the courts proceed with the remainder of the Central Hudson analysis. Both parties agree that the information on Tofurky's packaging, labeling, and marketing materials represents commercial speech. The parties disagree as to whether that commercial speech merits First Amendment protection. Arkansas argues that Tofurky's labels for its plant-based products are inherently misleading because they use names and descriptors of traditional meat items but do not actually include the products they invoke, terms like chorizo, hot dogs, sausage, and ham roast. Additionally, the state points out that Toferky designed its food products to approximate the texture, flavor, and appearance of meat derived from slaughtered animals. The state believes these factors make Toferky speech inherently misleading. Toferky counters that the state's argument is not plausible, as the words such as meat, burger, and steak have been used for decades, and in some cases centuries, to describe foods that are not made from slaughtered animals.
I would also argue that the main audience for Tofurky, like their main consumer base, are people that are looking for plant-based alternatives. So it is not within their best interest to hide the meat-free nature. That is usually the selling point. So it doesn't make sense necessarily for them to have packaging and explanations on it that negate the tofu part of the Tofurky.
Yes,
And
I
so I
agree.
would say context matters. And people are able to make context-based decisions. If I have hamburger buns, I do not think that that is made from beef. I think that they are buns that you put around a patty. Like that's fine. You can use words like hamburger without it being a meat product, and people from context will be able to tell what's happening.
Yeah, people perhaps are not complete idiots. One can only hope, although then again, given many of the lawsuits we covered, I'm not sure how much our deep faith could truly extend to that principle, but let's keep on with it anyway. The court has 7 labels before it on the record. These labels are for products the court will refer to as veggie burgers, deli slices, chorizo-style sausages, slow roasted chicken, original sausage kielbasa, hot dogs, and vegetarian ham roast. The court considered these labels before it on the record and considers the speech at issue not to be inherently misleading. It is true, as the state contends, these labels use some words traditionally associated with animal based meat. However, the simple use of a word frequently used in relation to animal based meats does not make use of that word in a different context inherently misleading. Now, the court is going to more closely analyze the exact labeling at issue to decide whether or not the labeling, when considered as a whole, is misleading or not. The Veggie Burger label has the word veggie modifying the word burger and includes the word all vegan in the middle of the package. Further, the Veggie Burger label features the words white quinoa next to the picture of the burger. The Deli Slices label also includes the words all vegan in the middle of the label, features the words plant-based next to the picture of the product, and describes the product as smoky ham style. The chorizo style sausage label includes the words all vegan and states the product was made with pasture-raised plants. The slow roasted chicken label has the words all vegan right next to the product's name and describes the product as plant-based in the bottom left corner. The original sausage kielbasa label includes the words all vegan next to the word sausage and identifies the product as Polish-style wheat, gluten, and tofu sausages. The hot dog label has the words all vegan next to the word dogs and plant-based under the word dogs. The vegetarian ham roast has the words vegetarian modifying the words ham roast. Each of these labels also features the letter V in a circle on the front of the packaging, a common indicator the food product is vegan or vegetarian. Finally, each of these labels features the company name Tofurky, which clearly contains the word tofu in a play on the word turkey. The court does us the favor of explaining the joke, which is always just great. The state appears to believe the simple use of the word burger, ham, or sausage leaves the typical consumer confused, but such a position requires the assumption that a reasonable consumer will disregard all the other words found on the label. Under plaintiff's logic, a reasonable consumer might also believe that veggie bacon contains pork, that flourless chocolate cake contains flowers, or that ebooks are made out of paper.
They're not? Shoot.
Ebooks, in fact, are not paper. No. It is very sad. Even though I would like to point out that Amazon calls its product right now the Kindle Paperwhite. So, hey, maybe there's some deception there. Let's go talk about Amazon, about the massive deception in their marketing, right?
I am an average consumer and I am confused.
Yes. Yes. Not paper in my ebook. It's more likely than you think. Tune in at 11. The labels in the record evidence include ample terminology to indicate the vegan or vegetarian nature of the products. Additionally, there is no contention that any of the consumer or potential consumers were actually misled or deceived by the packaging. I'm impressed that you couldn't find anyone who was deceived, but apparently there was no one who was deceived, so noted. As a result, Tofurky is likely to prevail on its arguments that its labeling is neither unlawful nor inherently misleading, and Tofurky's commercial speech warrants First Amendment protection. Accordingly, given Tofurky's likelihood of success on the merits of this point, the state's speech restriction is subject to intermediate scrutiny under the remainder of the analysis. Therefore, for the foregoing reasons, the court finds that Tofurky is likely to prevail on the merits of its First Amendment claim. Because the court concludes Tofurky is likely to prevail on the First Amendment claim, they decline to examine the 14th Amendment claim.
I did have another thing that I sort of wanted to bring up in terms of a broader picture here.
Sure.
The reason why I was so excited for you to cover this is because the laws seemed to do the opposite of what I would hope from consumer laws. So like consumer laws in my head, the first thing should be to protect the consumer or enhance their experience or to give them rights or benefits. And this is really helpful when you have an individual consumer against a large corporation. You kind of even the battleground a little bit by providing consumer rights. The second aspect would be that you don't want to be unduly burdensome on a company because it actually benefits consumers for companies to be able to offer products. And if you're unduly burdensome, you can decrease market competition and you can actually increase the price of products because companies have to spend more money in order to get around these regulations. So it should be sort of minimum regulations, which are good for consumers, but also enough regulations that they are protected and have rights. And I don't see this fulfilling either of those two things. I don't think that consumers are confused or have ever been confused. Like, was there a massive consumer movement where everybody said, well, I was in this special vegetarian section of my grocery store and I picked up something that I thought was turkey, but it's actually Tofurky, and now I feel cheated. Like, I don't think that was happening. I don't think that there was a massive movement by consumers saying, wait a second, I can't tell what the ingredients are in my food, when there's a giant ingredient list and when the marketing clearly points out what is plant-based and what is not, because vegans and vegetarians also want to clearly, quickly be able to establish what food is good for them. I think that so it's unduly burdensome on the companies, and it doesn't actually provide anything positive to the consumers. So who is benefiting from this? And I believe it's a call out to the meat industry. I think that it's trying to stifle meat alternatives and create burdens on that part of the economy so that meat producers and providers would have a leg up. And I don't think that that's the purpose for consumer laws. I don't think that increases competition. I think that's kind of anti-capitalist. And I also think that's anti-First Amendment, because any restrictions to me should go under strict scrutiny. You have to really justify those restrictions. So who is going to be harmed if you don't have this law? And the answer is no one's being harmed or has ever really been harmed on a large scale. And there's no incentive for companies to try to deceive consumers. So it's not something where, like, well, we anticipate that a bunch of companies are going to try to deceive people, so we have to crack down on them. I don't think that there's been any widespread.
No, I agree, and it seems like its purpose is to target the meat industry, or even maybe perhaps more sinisterly, I think maybe its motivation is to basically say vegans, aren't, we have no vegans in Arkansas and they're not welcome here. It's more we eat meat with brand law meat in Arkansas. Is probably the motivation behind this law, if I had to guess. Also, helping the Arkansas ranchers probably had some part of it, I'm sure.
And I think it's a little bit interesting to me that I wasn't aware that meat alternatives were such a huge threat to ranching or anything like that. Like, about once a week, I try to have sort of a vegetarian meal or whatnot. But part of that is a cost thing. Part of that is a health thing. Part of that's just I like variation in my diet. I don't always like eating really meat heavy meals, and being able to cook things that are vegetarian and
No.
vegan and meat filled and barbecued and roasted and like everything. I like having that variety there. I wasn't aware that the meat industry was really suffering right now. That would require them to have this
And I
call
want
out
to
from the
and I want to move
legislature.
to either Argentina or Brazil, where it's all meat all the time and nothing else, and only meat, all meat for every meal. Go that South American, Argentinian, Brazilian way. Probably more Argentinian than Brazil. So maybe Argentina and I should have get along. Move my law practice to Argentina. That'd be good. Argentinian lawyer. So that is the end of the case of Turtle Island Foods doing business as Tofurky versus Nickel Salmon. In this case, we learned the state of Arkansas passed a law that prohibited plant-based foods from using any meat-based words, no matter how much other packaging was on the label. And the court, applying intermediate scrutiny against commercial speech, noted that deception and falsehoods are not allowed, but also noted in the full context of these packages that it was more than clear that they were not meat-based products, and so concluded this was a First Amendment violation, and that's the end of our discussion of that case.